Hello, everyone.
Is it on?
Like I said,
You should be good.
hi. Welcome to today's panel. This panel on involuntary servitude, slavery, and constitutional law. This mic is a little bit intermittent. Testing. Welcome to this panel on involuntary servitude, slavery, and constitutional law. My name is Sapp. I'm a staff attorney at Legal Services for Prisoners with Children. And we have an excellent panel that was convened on relatively short notice. So we've got a lot to talk about today. And I'll begin by introducing the panelists. And the way the session will work, I'll pose some questions to the panel. Then after that section, we'll go into audience Q&A. So on Zoom, we have Dean Erwin Chemerinsky, who is the Dean of Berkeley Law School. He's the author of scores of articles and books, among which is a recent title, Worse Than Nothing, The Dangerous Fallacy of Originalism, which was published in 2022, and he's got more books since then as well. Here on stage, Carmen-Nicole is Director of Government Affairs for the ACLU California Action and President of the Cox Firm for Law and Policy. A self-described liberation attorney, Carmen fights for poverty alleviation, community prosperity, and Black joy. Just to my left is Jay Vasquez, who is the Policy and Legal Services Manager at CURYJ, that's Communities United for Restorative Youth Justice. Jay has worked on numerous legislative policy efforts in California on issues of criminal and juvenile justice reform, voting rights, and the restoration of visiting rights for incarcerated persons, and prevention of police misconduct. Also joining us on Zoom is Brandon V. Stracener, who is a civil litigator and senior research fellow at the California Constitution Center. Brandon is author of several publications on constitutional law, including state constitutional law. Brandon has been a media commentator on radio, TV, and newspapers, and contributes to a blog on the state Supreme Court. And last but not least, on stage, on the stage right, is Lawrence Cox, who is the Regional Advocacy and Organizing Manager at LSPC, and someone I'm proud to call a colleague and comrade. So, organized violence has marked U.S. history and its legal legacy since the early modern period. The ancient Greek philosopher Heraclitus famously said, "War is father and ruler of all things. Some it enslaves, others it sets free." Sadly, U.S. history has illustrated this principle. It took a literal war in the 1860s to put an end to legal slavery in this country. The 13th Amendment, which said that neither slavery nor involuntary servitude shall exist in the United States, nevertheless had an exception clause for punishment for a crime of which the party has been duly convicted. Various state constitutions had equivalent exception clauses to the ban on involuntary servitude. In California, Article 1, Section 6 has an exception, what's now Article 1, Section 6, and was, I think, Article 18 of the original state constitution also has an exception for the punishment of crime. Efforts in recent years to amend that state constitution have not been successful. Most recently, you may recall Proposition 6, which was on the ballot in November of 2024, which failed, which passed the legislature by 2/3, but did not get enough votes to pass with the electorate. So we're going to reflect on these legacies on various levels of generality. My first question will be a rather broad one, and I'll begin by asking Dean Chemerinsky, how do you understand the logical relationship between involuntary servitude and slavery as legal concepts?
As I said before, thank you so much for including me and allowing me to participate by Zoom. I think it's important to recognize that the drafters of the 13th Amendment didn't simply say they were prohibiting slavery. They intentionally included the words involuntary servitude. Slavery had a particular meaning at the time. It's what those of African descent were subjected to in the southern United States and other parts of the country. Involuntary servitude was meant to have a broader meaning. Unfortunately, in the slaughterhouse cases in 1873, the Supreme Court, when it first interpreted the 13th Amendment, largely collapsed these terms, and thus it's been very difficult to show something to be involuntary servitude in violation of the 13th Amendment, unless it's quite similar to what enslaved people were subjected to before the Civil War. And of course, what we're really focusing on is the language of the 13th Amendment that abolishes slavery and involuntary servitude, except as punishment for crime.
And Brandon, does the state of California's concepts of involuntary servitude and slavery mirror those of the federal government, or is there room for difference of meaning in the concepts?
I would say they probably largely mirror what the 13th Amendment was intended to say. I would also note, as a historical note, I think that many are aware of, the California Constitution had this distinction, this exception for prison labor or work in labor as involuntary servitude. That exception existed before the 13th Amendment existed as well. So this was a feature of the state constitution well before the 13th Amendment came to pass.
I just want to note for y'all that in 1974, California reorganized its constitution. And one of the things they did that is interesting here is the language that we see now. That's the consequence of a ballot proposition from 1974. And before that reorganization, it was actually much more conflated, involuntary servitude and slavery. And then in what was supposed to be more of a technical cleanup, we have the language that we see now, which intentionally tries to make involuntary servitude and slavery seem very different, very distinct. But at the end of the day, what we're talking about, whether legally, logically, physically, spiritually, is that folks are being compelled to give over their talent, their human labor, their skill, their time, their energy, their effort, whether or not they want to, right? And so I definitely appreciate the dean and couldn't possibly disagree with him. But for sure, what we are right now, what we're trying to do, what we're trying to make is both name that these two things are actually one in the same, at least in the way they land on the human body, and particularly the black and brown body, because those are the bodies that are being targeted. So they land on the body the exact same, and it's very important that while there's might be legal rationale behind why courts want to treat them differently, for our purposes, it is very important that people see that there is no distinction in the way that it lands on the body and the way that the exploiters, previously the colonizers, the masters, the slave owners, the way that those folks benefit today, because they're still very much profit.
Yeah, I think I appreciate Carmen for doing that. I think that's been part of the challenge for people to wrap their heads around what involuntary servitude in the California partial system is like today, right? Because for me, when I think of the word slavery, my mind automatically goes to the Black experience in the South, right? And if I go to that experience and look at how people are treated and incarcerated today in California, there is a difference in that sense, right? Now, speaking with someone who's served for 25 years, inside California prisons, right? So I think at the end of the day, though, what Carmen said is right on point in the sense that we know that forcing somebody to labor and punishing them, right, takes away that person's, dehumanizes them, right? And so what we're talking about here is really saying that people have a fundamental right to how their bodies are used, right? Even in the carceral setting, regardless of what they've done. People should not be punished, which they currently are, for missing work because they're sick and they didn't get that medical aid in time. People shouldn't be punished for being injured on the job, right? And then being expected to go back to work right away. Or maybe someone wants to do like a different self-help program, and are able to because they're going to push their work hours, and if they choose to go to that self-help program instead of work, they can get rid of them, right? So we know that people are being punished for abuse of labor, and that's something that we want to really uplift, is that that's how it's tied into it. And I hope we go, I'll touch a little bit more maybe on the history of how that ties into, especially in California. I think it was Brandon that talked about, like, we think of the 13th Amendment, and that's a very real thing. And we all also remember, though, the exception clause in California was 16 years before the 13th Amendment, right? So I think what California got to look at is the unique perspective before even San Quentin was built, before even the first prison was built, right? There's so much that goes into it with California being accepted into the Union. You got to remember the 1850 Compromise. The biggest deal on that compromise, that California had to enter the Union as a free state. That was part of the deal. The problem, though, is that Peter Burnett, the governor at the time, slaveholder, James Still, Senator James Still, who happened to be the San Quentin contract, the slaveholder at the time, right? So you have all these white men in California legislature were like, oh crap, California has to enter as a free state. What are we going to do about slaves, right? So they got very crafty and came up with the exception clause in 1849. It was ratified in November 1849. Just 5 months later, they came up with the Indian Adventure Act. The reason why the Indian Adventure Act is because it was the native peoples that were exploited in California. Blacks were exploited too, but that many blacks in California at the time, it's like right now, there's not many blacks, right? So these people were already being enslaved. A lot of these white legislators had them as slaves and was like, okay, there's a free state. How do we maintain our property? How do we maintain our businesses? And part of that was saying, okay, well now, we could exploit you for punishment of crime. And then a few months later, that's what they did. The red coats, some of the black coats later on, right? You're criminalized for being unemployed. You're criminalized for being homeless, or loitering, or living in a moral life. So any white man could take that native person before a white judge. That white judge would then hire that native person on an auction block within 24 hours. The native person could not testify against a white man. And that went on in California early on. So I just wanted to tie it back to the history of how they got in, because when people look at it today, it was very different. So people don't make that connection as a huge mistake.
Thanks, Jay. I want to go back a little bit even further in history. Dean Chemerinsky mentioned the slaughterhouse cases in the 1870s. As Brandon and Jay noted, in the 1840s, the state constitution had an exception for involuntary servitude. Involuntary servitude as a legal concept in America even predates the Constitution itself, and at the risk of falling into presuppositions about originalism, I want to ask the Dean what he thinks the original meaning of involuntary servitude would have been in the Northwest Ordinance of 1787.
I think when you focus on the Northwest Ordinance or early American history, you have to put it in the context of the society that existed then. Slavery was deeply entrenched in the southern states at the time. Slavery was protected by the Constitution when it was written in 1787. Several provisions very much were about entrenching slavery, that Congress couldn't ban the importation of additional people for 20 years, when only 2 provisions that couldn't be amended in the Constitution. the provision that enslaved people would count as 3/5 of a person in allocating seats in the House of Representatives, the Fugitive Slave Clause in Article 4 of the Constitution, that an enslaved person escaped from a slave state to a free state, the enslaved individual had to be returned to his or her owner. It was clear at the Constitutional Convention in 1787 that any effort to try to even chip away at the institution of slavery would have meant that there wouldn't be a new constitution. North Carolina, South Carolina, and Georgia all said that they would leave the Constitutional Convention if Congress had the power to ban the importation of additional individuals. So when you talk about the Northwest Ordinance, it was very much a focus on slavery in the context in which it existed in the South for those of African descent.
Does anyone want to add any thoughts about the founding conception, the conception of slavery and voluntary servitude at the founding? Brandon, perhaps?
No, I think here this is bang on from the dean, and I don't think there's anything I have to add. I think that understanding likely informed the state constitution, drafting for California and many other states as well.
So bringing things rapidly up to the present, the current, Proposition 6 of 2024, following upon ACA 8 of 2024, would have prohibited slavery and involuntary servitude, eliminating the exception and specifying that the California Department of Corrections and Rehabilitation could not discipline anyone for refusing to work. The current effort at a amendment to Article 1, Section 6 is known as ACA 6, which would eliminate the very words involuntary servitude entirely from the state constitution and say, in relevant part, simply slavery in all forms is prohibited. What are the implications of that legally and politically? Lawrence, you want to kick it off?
Of course I can keep it off. I'm not the constitutional expert, but guess what? This is so simple, y'all, so I don't need to be. If we're not trying to ban involuntary servitude, then yeah, we can have any type of language. We can water this language down, we can leave openings for loopholes, we can leave openings for misinterpretation and litigation that follows, and guess what? The practice continues while all this is going on. I think the implications are great because if we put so much effort behind passing the legislative process and then just that we get to, the ballot again and we pass, how much energy is it going to take to go re-amend what we done already fixed? If we're going to take the energy to go through these processes over and over, and trust me, we're willing to do it because we've been doing it for years, wouldn't we prioritize making sure that we close that loophole in every form and fashion, period? Well, guess what? If the language that we have right now, 475 or ACA 6, if we can't amend this language and make sure that we're specific and we're calling out involuntary servitude as well, then guess what? We're not doing justice for the individuals that we're fighting for. We're not doing justice for all the individuals that have been subjected to it, like me and Jay, and a lot of us in this room has experienced involuntary servitude and know exactly what that feels like. The implication, I believe, is great. We look at the states that have already amended their constitution. We see, guess what? The practice still continues. If we look at all the legal matters that are still, going forth, the misinterpretations that, are allowed to be passed back and forth on, guess what? It didn't do the job. And the implications for California is just what we follow in their footsteps. I think maybe Colorado may have had some of the strongest language that we could potentially, I don't want to say draw from, because the language that we had, like Eric said, with ACA 8, when we passed that, I think that would have been the strongest language in the nation. Because not only did we call out everything that needed to be called out, but we also made sure that the carceral population was protected through the Constitution and they weren't punished for choosing to to forego a job, but a voluntary job, should I say, and, you know, decide they want to partake in rehabilitative courses. And with the language that we currently have now, if we don't amend, then guess what? All that goes out the door. If we not pass the legislative process with this language, there's no reason, I believe, and I'm pretty sure everybody else would agree, that the language should be changed to something that's less significant and, you know, just do this, this symbolic dance all through the Capitol corridors and then, you know, up and down California State with another campaign. I'm not trying to do that symbolic. That's hard work. So the implications really in so many different ways and factors is truly great.
We're going to pass it to the Dean to get your expert opinion on this. The question is currently ACA 6 goes silent on voluntary servitude, right? So it will not say anything about prohibiting voluntary servitude, it just says slavery in all forms. Assuming that were to pass as is, can CDCR continue the practice of involuntary servitude because it will not be strictly prohibited in the state constitution? You're on mute, sir.
If I understand the question, Article 1, Section 6 of the California Constitution now says slavery is prohibited, involuntary servitude is prohibited, except as punishment for crime. And the question would be, what would it mean to strike out the second sentence and leave in the first? I think it's unclear what that would mean. I think the problem that you have is that under the California Penal Code, Section 2700, it says, the Department of Correction shall require of every able-bodied prisoner imprisoned in any state prison as many hours of faithful labor in each day in every state during his term of imprisonment as prescribed by the rules and regulations of the Director of Corrections. I am not sure, no one can be sure, whether striking out the second sentence of Article 1, Section 6 would be sufficient to declare unconstitutional Section 2700 of the Penal Code. It seems to me the best course is to either overrule, have the legislature repeal Section 2700, or to amend the California Constitution to make clear that prisoners cannot be forced into work. Somebody's already mentioned Colorado has done that with a constitutional amendment. But I worry that simply striking the second sentence of Article 1, Section 6 is ambiguous as to what it would mean with regard to prison labor.
And I feel very confident, Dean, that the language in ACA 6 neither would prevent CDCR from being able to force folks to work, nor is it intended. Because if we read AB 475, which is supposed to be sort of implementing statute, it explicitly says, except as otherwise provided in section 2700.1, the department shall not require incarcerated persons to work. Now, the entire point of us amending the Constitution is to remove any exception to the government's ability to compel people to work, to exploit folks for their labor. It makes no sense that at the same time, the same author is running a bill that says, accept these kinds of people. Now, I'll tell you who those people are. The folks that are accepted, who would still be, who could still be compelled to work, are folks who have been convicted of murder and sentenced to death. If the intention of ACA 6 was to prevent, full stop, involuntary servitude, then there could not be any exception. You could not then pass a state law that permits an exception. So it is very clear from my legal interpretation that ACA 6 neither does nor intends to stop, to prevent, to prohibit forced labor. It couldn't possibly, because the same person who wrote it also wrote this exception into a law that is supposed to implement ACA 6.
One of the pieces of language that ACA 6, the proposed amendment, would do is add the phrase "in all forms" to modify the word slavery. Brandon, do you think adding that qualifying phrase has any meaning whatsoever were ACA 6 to pass, amending Article 1, Section 6 to say slavery in all forms is prohibited.
I think that's helpful, and I think the mention of the partnering, or also, the partner, I guess you could say, partner statute to be implemented alongside ACA 6 would help bring clarity to the intent. I think the larger concern might be what are the legal implications of the change, right? How does the legal landscape change? And there are certainly a lot of unknowns. I think those could be handled through further refinement of the constitutional amendment language. But there are certain things that the state of California can't account for. Just as one brief example, and there are a host of these, and it doesn't mean it's not worth taking this policy stance or pursuing this policy path. It's a question of how do we address all the legal hurdles that are going to arise. And one of them is that we can't control the language of the Fair Labor Standards Act, the FLSA, which is federal legislation that in part sets a federal minimum wage. So as I understand it, looking at a lot of the implementing legislation on ACA 6, and the intent, I think, was to allow the California Department of Corrections to set volunteer work programs or wage amounts. But current Federal Court of Appeals decisions rely heavily on the currently existing constitutional provision as a justification for why inmates in California are not considered employees under the FLSA. If that provision changes, other California statutes won't save it. Courts have rejected statutory bases. They really rely on this exemption to involuntary servitude to determine that prison inmates don't need to receive federal minimum wage. Now, I'm not saying that's wise or unwise as a policy matter, but it does introduce a huge, I think, hurdle or obstacle or just something to chart in terms of the billions of dollars of increased cost to the California budget to pay federal inmates minimum wage. And then other concerns I have are, would the California Department of Corrections Rehabilitation just eliminate work programs, eliminate rehabilitation programs? If they offered volunteer programs, I'm concerned that under the federal statute and federal regulations, they couldn't even offer credits, any form of credits, any form of compensation whatsoever, or that volunteer program would lead to minimum wage requirements. And if there's no budget for that, then the program simply vanishes. So there's a lot of concerns about how much this will help inmates and how much it will harm them. And then another thing to consider, I think, as well, is California. I love that California has robust direct democracy provisions. I love this state for what it does, and it also has an active legislature, which is wonderful, that actually passes laws now and again, which is it's a distinct contrast from the gridlock we see at the federal level. One of the benefits of that is we have different ways to chart this course, and one concern here is there are a lot of unknown outcomes that will ripple from a constitutional change like this. Doesn't mean it's not worth doing. But it could also raise the question of, should we just have the legislature work through regulation and statute to change this circumstance? And doing it that way means once the legislature makes a mistake, not that it ever does, but none of us are perfect. And the legislature has the agility and the adaptability to recognize wrinkles and problems as they arise and pivot, make adjustments. If we enact this through constitutional amendment, if we lock further amendment to voter initiative only, that means if there is a problem and we have created unknown variables or problems that actually hurt inmates, we have 2 years later to fix that. Those inmates have to wait for 2 years until their lives get back to normal or improve in any fashion. And it means we have to convince voters again to sign on to it, which is, as we have seen historically, is a heavy lift sometimes. Even for really good causes, the voters sometimes take some convincing to sign on to something that even seems like amazingly sound policy. So one path could be, looking harder at regulatory and statutory adjustments and, letting the legislature, do what it needs to do. And then when inevitably there are wrinkles that arise or issues with the interaction between this change and the California Labor Code, or other various statutory or federal law, that the legislature can adapt and fix the problem and ensure that we're actually doing what we intend here, I think, or what advocates of this change intend here, which is to make incarcerated people have a more just experience while they're serving their time.
Lawrence?
I want to jump in. And I agree with Brandon. Of course, there are a lot of unknowns when it comes to what could trickle down But one thing, okay, maybe two things. When we're talking about job assignments being voluntary, job assignments are totally separate from rehabilitative courses. When it comes to good time credits, we get good time credits whether you get a job or not. So the California Department of Correction being able to award good time credits for not getting in trouble doesn't change. And just, I want that to be clear. There is no overlap. I can be in prison for 17 years, which I did, and not have one job. Guess what? I'm getting my good time credits. It's not because I have a job. And what the bill does, either or bill, we're not touching rehabilitative programs and asking them to be voluntary. If anything needs to be mandatory, or maybe Penal Code 2700 needs to say, rehabilitative programs need to be mandatory. But currently, as the two bills stand, and as every other iteration of these two policies, calling for involuntary servitude to be removed has never sought and never could cross over into the purview in changing rehabilitative courses to even operate or look anywhere similar to what we're trying to do. But the second thing, I agree working with, the legislation, changing Penal Code 2700 in operation is a good way to go, because guess what? The Constitution doesn't mandate, it allows it. It's Penal Code 2700 that actually mandates that incarcerated individuals are forced to labor. And guess what? They can do so because of the Constitution. But if our current climate doesn't show you anything, legislative statute can get changed the next year, 4 years. Look what we just went through with Prop 36. I don't think it will lose any of us to sit there and bet on a legislative change that can be changed by the new regime next time they come in. Look at all of our nonprofits right now that are suffering because of budget cuts. Guess what? It's a lot of policy that was put in place to make sure that people like us can do the work that we've done. And guess what? A whole new regime then came in, and or voters, and they reversed that. It's much harder and a harder climb when you're trying to change and manipulate the Constitution. That's why just simple legislative change at a state level is not security enough, because we want to end the practice forever. And I'll leave it at that.
Thanks, Lawrence. Switching gears to look a little bit at case law. This question is first for Dean Chemerinsky. The 1988 Supreme Court case, U.S. versus Carmen-Nicole, defined involuntary servitude, and I believe it's still the leading major case interpreting that for the purposes of federal law. And the majority, in an O'Connor opinion, adopted a conception of involuntary servitude here, interpreting the federal criminal statute, but under the assumption that it was homologous to the constitutional concept. Interpreted voluntary servitude in terms of physical or legal coercion, and rejected a broader psychological coercion concept that Justices Brennan and Marshall in their concurrences had favored. Do you think the O'Connor position was correct, or the Brennan position, or none of the above?
I think the Brennan and Marshall position is correct, because coercion can occur in many different ways. Psychological coercion is still coercion. Group pressure is coercion. There can be economic coercion. I think that the O'Connor definition of physical and legal coercion is too narrow. But to go back to what I started with, that's really what the slaughterhouse cases were saying back in 1873, that it was really focused on it having to be akin to the kind of slavery that existed before the Civil War for those of African descent. And that's been consistent through the case law ever since. Let me also add as an aside here, the issue is coming up now under the Establishment Clause of the First Amendment, where the conservative justice is saying, only coercion is enough to violate the Establishment Clause. And Justice Thomas Scalia made clear that they believe it has to be legal coercion and nothing else. I think to the extent that the conservatives are going to want to take that definition in the Establishment Clause, makes it likely that they're going to continue to want to use it in other areas as well.
There's a theory that is quite radical in its implications that was articulated by a number of scholars, including Adam Davidson of University of Chicago recently, that argues that, in fact, most prison labor today should not be deemed to fall within the exception clauses because it's not, strictly speaking, a punishment. That is to say, unlike a century ago when it was very common for there to be sentences to hard labor and the like, today someone is only sentenced to time, and it's a matter of legal inference and implication from other statutes and regulations that that sentence translates into a work mandate. Or you mentioned today was Penal Code 2700, but rarely, if ever, is someone sentenced today. When someone is sentenced today in California, it's very rare, if ever, that Penal Code 2700 will be announced as part of their sentence. Is there anything to this theory that the exception clause in both in federal or state law is being misapplied? I'll throw this to Brandon first.
Sure. I'm inclined to, not that I perfectly predict court outcomes ever, but I'm inclined to think that I'm highly skeptical of any court, state, or federal adopting that theory. I think in this context, if there's any amount of this that to any extent is punishment or penological in nature, then a court's going to find that it falls under that exception. I do appreciate the theory and the idea. I just think that the court's going to err toward that. And I think it probably would persuade or make a compelling case by pointing to the extremely low wages that fall under minimum wage. This has to be at least substantially, penological in nature if you're going to pay that ridiculously low amount. So there's got to be a substantial amount. If there's a substantial amount in there, without that, what purpose would that provision serve, right? If it had to be entirely penological and the sentence had to be purely nothing but hard labor, it would seem that those provisions would be effectively nullities at this point. They would just serve no purpose. I think a court would avoid construing constitutional language in that manner.
May I add one thing? I completely agree with Brandon here and what he said. I really liked Professor Davidson's article, but the premise of his article is that each court would have to individually sentence the individual to prison labor in order for it to be imposed. The difficulty is, as long as we've got California statute, Penal Code Section 2700, it imposes that as a punishment on all who are convicted. And so I don't think that there needs to be an individual finding in any particular case in order to be able to impose this. So I find it an appealing theory, but I agree with Brandon. I think it's very unlikely the court would use that theory to invalidate Section 2700.
So there's a whole range of other practices that courts often discuss in the context of decisions about involuntary servitude that have nothing to do with criminal punishment, such as mandatory jury service, material witness, compulsory material witness service, and service in the draft in the armed services. Does a exceptionless ban on involuntary servitude touch any of these other practices? I'll ask Dean Chemerinsky first. Does an exceptionless ban on involuntary servitude call into question things like mandatory jury service, the draft, compulsory material witness service, and the like.
The Supreme Court held early in the 20th century that the draft is not a violation of the 13th Amendment prohibition on involuntary servitude. Every court, to my knowledge, has rejected the argument that jury service is involuntary servitude. And this come up in other contexts. There have been a number of challenges to mandatory community service as a condition for graduation to public high school. And the courts have completely rejected that that should be regarded as involuntary servitude. I think it's possible to say that involuntary servitude is forcing somebody to work for 25 cents to $1.25 an hour, which was paid in California. And that's very different than a civic duty with regard to we all have to do jury service, or we all have to serve for the draft, or even community service. So I don't think that there is a problem in distinguishing mandatory prison labor under California Code Section 2700 as opposed to jury service, the military draft, or community service in high school.
Yeah, I'll just chime in that I agree there, and I think of the host of unknown variables and potential, legal problems that will arise, the whole can of worms that could open with a constitutional amendment here. None of those are among them, thankfully.
My understanding is that Dean Chemerinsky needs to leave in a few minutes. So if the audience had any questions specifically for Dean Chemerinsky, could you please raise your hand and I'll bring the mic to you. Does anyone have a question specifically for Dean Chemerinsky? What does it say about the attitudes of the California electorate that Proposition 6 did not pass and lost by about 1 million votes this past fall? Was that a function of an unclarity in communication of legal issues to the general public, or was it a reflection of the deliberate attitudes of the population? Carmen, do you have any thoughts on that?
I have so many thoughts. During the campaign, we talked to a lot of folks across age, across socioeconomic status, race, and gender identity. We talked to so many people. And quite honestly, there were a great many folks who do not understand the conditions inside. We are a very punitive society, and we conflate accountability with strict punishment. And I would say that particularly in certain communities, that is true. So I think it is in part attitude, but our attitudes are learned. These are learned understandings about what it takes to make our community safer, about what rehabilitation looks like, about what redemption looks like, about what accountability looks like. And I do think that in some ways we fail to connect with enough folks who hold the attitude that this brutal and inhumane treatment of individuals is somehow accountability. People were literally using the word accountability as if the only way that you can exact accountability, that you can achieve accountability, is to lash a man across his back. And failing to connect with more people to have the conversation, to help them to unlearn. Literally, we are steeped in this social climate that says, particularly for Black and brown folks, these are people who need to be whipped into shape. And but for that, they will not, cannot join us safely in society. It's why we marshal so many of our folks, Black and brown folks, into these cages in the first place. And the idea that they would sit in these cages and not be whipped, folks genuinely felt like that would, in some ways, have people avoid accountability. And you have to talk to a lot of people in a state of 40 million folks, and tens of millions of voters. Obviously a million voters difference is a big gap, but also I will tell you that on the budget that we had, that we reached, the millions of folks that we did, was an amazing accomplishment. But we're literally, y'all, this is a system that has existed. We've been talking about 1840s, we've been talking about 1870. This is a system that folks don't know anything different. This is what we know. And so much more, just like the past Proposition 36, the guards, the prison guards, and Walmart and Home Depot, and the prosecutors had to spend millions and millions of dollars to get that passed. We didn't have those same millions and millions of dollars. So the people that we weren't reaching were being reached by Prop 36 dollars that said, people are bad, and you gotta treat them real bad, and you gotta make sure that if they commit a crime, you gotta hold them accountable. And what does accountable look like? That they go inside and they get exploited. So yes, there was attitudes that we failed to be able to reach, and yes, there was a lack of resources, I believe, on the part of Proposition 6, because we weren't just combating centuries of a misunderstanding of what humanity looks like and what accountability looks like, but we had the Prop 36 dollars on the other side telling people the exact opposite of the story that we were telling.
To add to that, another thing was, because of those resources, we couldn't effectively reach the crowds, but also the timing. When we began campaigning with Proposition 6, we had 2 months, if that. We really were behind the ball when it came to initiating and establishing the committee, and also being able to, mount up. It was a tremendous effort. This was all grassroots. We weren't top up. We weren't top down. Excuse me. We were bottom up. If anything, I do believe we actually raised more money than the top down. Excuse me. But those efforts, with the lack of time, with the lack of resources, we've also seen the confusion, and the confusion with the way the ballot was actually written. We tried so hard. Attorney General is responsible for what the actual ballot title and summary will be. Like, we can submit and we can argue what we feel it should be and what we feel it should say. It doesn't mean that we're going to get what we want. And a lot of people did report afterwards that they were confused. And some people, when we were reaching them, they had already voted, but they voted the opposite way. And that was because they didn't understand. The ballot was confusing to them, and had they been educated in an effective moment in time, they would have voted with us, which is the opposite way that they did vote. And I think the communication, the education, I think it was key, imperative. I think it was something that we needed way more efforts at. And I think just, messaging like Carmen said, we've been in this system forever, and that's what we know. California is so super punitive. But one thing that we know, even these moderates, what affects them is, public safety and their lives. And I think we were inadequate in conflating the difference that Prop 6 could have made for their lives with, maybe a few more changes to legislation that can prevent some of the things that Brandon, said he felt would be coming down the pipe or potentially could be, but also there's public safety. Public safety, our stats and data has shown us that, guess what, tough on crime punitive measures has never done anything to make our streets safer. All it does is cause us to spend millions and millions and hundreds of millions of dollars. But if we could have been able to show that by removing the focus and prioritizing of involuntary servitude and making sure that it stays focused on rehabilitation, guess what? You increase the rehabilitation rate, which you want to decrease the recidivism rate. So that means that's less money. That's less money you gotta pay for a body. That's less problems and harm that's being caused in your communities. That's economic dollars generating revenue on local and state levels from these individuals who have actually been rehabilitated. And being able to get that message out and tie it into the wallets and, public safety, I think it's not like we didn't try, it's just we didn't reach them with the messages like we really should have, I believe.
Supposing hypothetically that ACA 6 passes and Assembly Bill 475 passes, we would be in a situation where involuntary servitude was outlawed for all incarcerated persons except for those on death row, pursuant to 27.1 of the Penal Code. Is there an argument to be made that such a situation would violate other constitutional norms, such as equal protection or cruel and unusual punishment? Brandon, do you have any thoughts on that?
Yes, I do. I think that would not create an issue. So if that's a pivot or an adjustment, I'm not sure that that's something that folks who want this to apply to every inmate would want to advocate for. But if that's what helps it pass, it could be a path. I don't see an equal protection issue, at least at a glance, because death row inmates, likely a court could easily conclude that they are not similarly situated to other inmates. The nature of the sentence is qualitatively and quantitatively different. So there's not a similar situation. As long as all death row inmates were in the same bucket and then non-death row inmates were in a different bucket, that's probably completely fine from an equal protection ground. And then for cruel and unusual punishment, I mean, if they're already on death row and we're not concluding that's a cruel and unusual punishment, I'm skeptical that requiring them to work 40 hours a week is gonna register, in a court's calculus at all.
Carmen, do you agree or disagree?
I'm gonna go ahead. Carmen, as a voter, Carmen, as a Black woman sitting here with family members who've been subject to this system, I really try not to put words and language into the universe that could harm our ultimate goals. So I'm going to decline to answer that question. What I will say is, at the end of the day, where we are right now is we have two pieces of legislation that say they want to help us achieve our ultimate goal of ending the forced labor of all people in the state of California. That's what we have. The legislation falls short. Thankfully, we have all you beautiful people here, and all your friends and family, all your followers, all your kinfolk, even the people who don't like you. The people who come to your social media because they don't like you, all those people that you have access to. We need to let folks know we are on the verge of being the first state in the union to amend our constitution in a way that effectively, that meaningfully, that actually ends forced labor of all folks in California. And we need some different words. We just need a few different words. Thankfully, it's all of us, and there's one person that we can all reach out to help us get to where we're trying to go. Her name is Assemblywoman Lori Wilson, Lori, first name, Wilson, Wilson. This lovely lady represents the Assembly District that covers, she's from Sassoon, she's got Solano, which includes Vallejo. These are the people out there she represents. And we need to have our people get in touch with her people and let her know that she's just a few words shy of where we need to be so we can get where we're trying to go.
We've got about 11 minutes left. I'm going to open up to the audience if you have questions, and then we'll allow our panelists to say some final conclusions. Troy?
When I studied law, I always looked at slavery and involuntary servitude. While they're the same thing, they were often used differently. And could you guys just go into maybe some detail about that, just so people can understand? Because if you leave involuntary servitude, you just mentioned slavery. and you don't specifically address involuntary servitude, they can still argue it. It's still ambiguous, like you said. So I don't know if people understand that they were both a part of slavery, but they believe it's different.
You know, I struggle with the euphemisms that the professor uses. Right? They're very crafty on creating different words that in practice are the same. And so when the way I look at it is I don't see the difference because at the end of the day, someone is still being exploited, their body's being exploited, they're not having consent over their body, and someone, an entity, in this case the government, is profiting off someone's labor, right? And so when you look at involuntary servitude and slavery, those of us that have lived behind the wall don't see the difference. We see it for what it is. We know that legally, the oppressor has crafted language legally to kind of make us see different. But in practice, we know it's the same. And I also want to say too that like it's important to recognize on the last conversation is that we are not okay with having exception to the exception. Right? We are not okay with that. So regardless if someone is on death row or sentenced to death, it's not okay to have an exception to the exception. You know, we're saying that slavery is wrong for one and wrong for all, and that's why we're sticking with that, right? Furthermore, at the same time in California, when Prop 6 didn't pass, you gotta remember that a similar measure passed in that at the same time. You know, why is that? You know, it's like California is supposed to be a so-called progressive state, but yet since 2018, what was it, Colorado, Alabama, Nebraska, Oregon, Tennessee, Utah, and Vermont all changed their state constitutions to get rid of this exception clause. Why? Because they tie it to the vestiges of slavery. It's not a secret that after the Civil War, the vast majority of states put this exception clause into their constitution. Why afterwards? So that had nothing to do with rehabilitation and punishment. No, it was a way to preserve slavery point blank. And we see that. And so it's hard, though, to really talk to people in that way when they don't fully comprehend the history and connection to what we have under certain cultures today to the ties of slavery that existed, you know, in the 1800s. But it's there, right? I personally made over 500 calls to people who are involved in making. And I can say this from my personal conversation with people, once I talked to them about what this would look like in practice, they agreed that it makes sense. You know, some of what the ones we're talking about, right, is that well, we want people to come home, we want them to come home on a healing journey. Well, guess what? Being after labor exploited in prison, there's no redeeming quality in that. We're not saying that work's not important, people want to work working. I like working inside of there. And then I need to get on myself, right? But we also know that even CCR, well, the whole board doesn't look at that as rehabilitation. I knew hell of people that were PIA for a lot of years, didn't really do self-help, but they were only for them. But guess what? They have all these good work reports. When they went to the whole board, guess what the whole board said? Yeah, you're working for 20 years, 25 years, you got all these outstanding work reports, you have no rehabilitation, denied. So if work was rehabilitation, then the board will recognize that, but they don't. So I think that's something else to like really put out there that it has no redeeming quality. Yes, we want people to work because people enjoy it, but people shouldn't be forced to work, right? People shouldn't be forced to have a say so on how they use their bodies. And that's what we're asking for. As it stands right now, there's twice as many people on CCR that there are jobs. So people are not even working right now, right? So it's like, we understand that people do want to work. It's not about like people not working. I think that was part of the misconception. Like, well, if you do away with this, people are not going to work. The prisons are going to shut down. You have to hire people in the streets, or you have to pay people minimum wage to work. And what that's saying is that once you take away that whip, then people aren't going to work. And what I hear when I hear that, it's the same argument that was made during Reconstruction. That if you don't force black people to work, they're not going to work because they're lazy. That's what people think.
And so when they say that, like, if you take away that width, the 115 is CCR, rather than that, people are lazy, not gonna work, it's gonna shut down. That's false. That's false. And so it's just, there's so much that we've got to counter, and I think at the root of it all, you know, the word racism has been brought up in this conversation, but I think that's the core of how this came about. We need to recognize it for that, because at the end of the day, when you look at the vast majority of people that are having their labor exploited in the carceral system, it's black and brown people. That's nationwide.
Do we have any other quick questions from the crowd?
I just wanted to add to that. I just wanted to add to yeah, I just wanted to, my name is Leonard Brown, I'm from work executive. I just wanted to add to that. I did 32 years of incarceration. And during COVID, a lot of us were thrown into the kitchen who was forced to work, even though a lot of us didn't want to work for the fear of catching the virus. But we didn't have a choice. We was actually literally forced, you're gonna work, or we're gonna write you up, haul you off to the hole. And literally was, you know, the threat from CDC. And some guys did, and they got hauled off. And yeah, so I was thrown into the kitchen. And so it was supposed to be a temporary thing, but guess what? It's like, oh no, you assigned to the kitchen. No, I don't want to go to the kitchen. Oh no, you're in the kitchen. So yeah.
Can I add on that? And that's what we're trying to accomplish here, right? We want to give people the autonomy to choose what they want to do on the inside. Because I remember being in there, we also talked about this too, is that most people inside want to work, but not everybody wants to work in the kitchen. Not everybody wants to run a yard crew. Not everybody wants to be a porter. I remember a lot of times I worked in the kitchen, I like working because I like to eat. You know, people don't want food. So I like my brother, I like to eat. But a lot of people don't want to work in the kitchen. They want to say, you know what, I want to work yard crew. But guess what? They didn't really have that choice. They could put that little exchange trip, but I get food over here, I get food over here. And a lot of times that didn't work. So what we're saying is like, look, we want to give people the autonomy to choose what they want to do inside there. Because we know people that are inside, we know when people go to the committee, go to the annual review, go to UCC or ICC, and they say, what do you want to do? And you say, you know what, I want to run a yard group, I want to do education, I want to do self-help. We know those positions are going to be filled. We know the narrative that if you don't force people to work, it's going to shut down. We know it's a false narrative because people do want to do things in there, but everyone wants to do something differently. Not everybody's the same. People should be forced to work somewhere they don't want to work. So that's what we're getting at the end of the day, is regardless if they're incarcerated, that's the punishment. Having your freedom taken away is the punishment. You shouldn't be punished upon punishment once you get inside there simply because, guess what? I don't want to get this COVID. Especially at that time, it was scary at that time. People were dying, people didn't know what that was. And yet, people were asked, or told, not asked, told to put their lives on the line or be punished. And for someone that's doing like all day, you know, that could be a multi-year denial, you know, from the parole board. You know, so think about that. And so that's a scary thing, and that's inhumane, and that's what we're saying is wrong with this right now.
Yeah, first of all, I just want to say thank you so much for providing insight into this issue. My name is Danny Thompson. I'm with Interfaith Movement for Human Integrity. I'm also assistant impacted person that spent 2 decades incarcerated, and I definitely, witnessed firsthand what forced labor is inside the carceral system. My question is, I know that it costs over $100,000 to incarcerate a person. I also been trying to look for the numbers, right? So how much does the prison system or the state of California make through, generating through forced labor of an individual?
I can't remember the exact number offhand. I do believe it's somewhere around 200 million a year that California may make. I could be wrong. I know nationally, if we look at all the states combined, just about 9 billion a year with a B. California, I do believe it's around 200. I could be wrong, but don't fault me for it. But a lot of people, to tell in, to tag on what you said, a lot of people don't look at if it was truly prioritized just to sit there and put rehabilitation above exploitation of labor, then I can give you a number there. We can just decrease recidivism by 13% here in California. We let off, what, 33,000 people a year, somewhere around there. Roughly a little under, maybe what's that, 4,000 people. If we just improve by 13%, at the rate that we pay per person in the carceral system, that's a little bit over $500 million a year that we can save. And those numbers are not accurate. Those numbers, like if we really calculate every avenue and every corner of savings, it's way more than that. And I think that's one thing that we don't prioritize. It's one thing that the system doesn't prioritize, because we're always talking about, what the fiscal budget looks like. We never want to speak on what the fiscal budget will actually look like when you begin to decrease your spending, because you are increasing the rate of individuals that are receiving true rehabilitation. And how that looks, not only that it's not coming out of the state pocket, but all the money that the individuals are generating in the tax revenue that is coming back into the state's pocket. Now, if we can add all of that together, those are significant savings that no one prioritizes uplifting when they're talking about how much a bill or, how much it's going to cost to make, effective change in our communities. And I think that's, I don't know, we have to find a way to make sure that that's the conversation and that's at the top of the list.
Brandon, we're at the announced end time, so I wanted to ask if you had any concluding observations.
Yeah, sure. And I did want to say thank you for the invitation to participate. This has been very informative, and thank you for inviting me to talk on such an important issue. I think the point just raised about taking a holistic picture about cost savings is very helpful to try to, I think, pitch this to skeptical folks. So I welcome that, and I think that will be a very helpful thing, because I think many people don't contemplate the value, the economic and otherwise, of a reduced recidivism rate, of having folks, being able to get out of prison and live normal, productive lives and have meaningful lives and be welcomed back into society. And yes, there's tax revenues that come from that. On one hand, should the money really be an issue here? And on another, I know an obstacle we often face when trying to convince the legislature voters to do something is folks immediately run to think of their wallets, even if that shouldn't be the primary consideration. So I think it's helpful to look at that complete picture. I will say that one of the values of being a Californian is that we have multiple paths to victory on any policy issue. So if the constitutional amendment can't get across the line, I understand, and I think it was an excellent point raised by the panel, that a constitutional amendment is more resilient to change. Correct. And that goes both ways. That's a benefit. It can be a drawback if the constitutional amendment creates worse effects for the folks we're trying to help. So there's always the path to pursue through the legislature statutory amendments, and to push the legislature to quickly react when there's a mistake or an unforeseen consequence. So if a constitutional amendment doesn't seem to be able to break through with the voters, the legislature will move, it will act, and it may not always be a benefit. Some will say it's not a benefit that the legislature acts repeatedly, but we even look in the field of housing. Again, folks will question how effective it's been, but the legislature has amended its housing statutes every year, year over year, to try to adjust and pivot as it's realizing, the effectiveness or lack of effectiveness of a particular policy. Yes, there are concerns about blowback, but I would say, I'd urge anyone, in California trying to make change, look at all of your avenues and your paths, and you may find, an alternative path to accomplish the same result. Sometimes that's just kind of the difficulty of getting something done in California. We're a large state. A lot of voters are skeptical of initiatives inherently, but there are multiple paths to victory. And, I commend the people here for, pursuing this path, and I wish everyone the best on pursuing this goal. And there's whatever the wisdom of the policy is, there's multiple ways to get there.
Thank you. Carmen, complete observation, 1 minute.
There are currently 2 vehicles, 1 author. Be in touch. Honorable Assemblywoman Lori Wilson. Be in touch with her.
Jay?
I'm not preaching to the choir, but just talk to your folks, talk to people. You know, the more they hear from us, the more they're gonna understand what this would mean, right? Because a lot of people, as was talked about, don't know the experience of an incarcerated person. They see what's on TV, they see what's in movies, and that's all they know, right? So it's up to us to educate them on this, to shift that paradigm on them, you know, things they have an understanding. And it's our lived experience in here that's gonna do that.
And Lawrence, I'll give you the last word. I just want to say thank you to all our panelists, both those who have stuck out to the end and Dean Chemerinsky, who had to leave early. It's been a great panel. And Lawrence, your thoughts?
I want to echo kind of what both of y'all said, but in more broader terms, do the work. Get out there and get involved. A lot of us, we have been in it. You know what? Keep that endurance and keep pushing. For those that haven't been in it, get involved. Whether it's talking to your legislative members, especially the author of this bill, whether it's partnering with, colleges, community college, the UCs in your area, educate. And there's others to help you educate. Volunteer to go somewhere else in another county that you've never been before, but maybe, need that education to get the work done, because it's gonna take all of us.